with a story about 3M, which produces many products, but relevant to our story today, produced earplugs for the military. These earplugs had two different ends. So you could put them in one of two different ways. And depending on what way you put them in, it gave you different kinds of protection. This was advantageous, obviously, because you might have different needs for different purposes. Unfortunately, the nature of the design prevented a proper seal from being formed. So that's a real problem, right? So if it had worked properly, then you would have had two different earplugs built into one, and you just put them in one way or the other, depending on what you need. But unfortunately, the plugs didn't work. They didn't provide a proper seal, so people got some serious hearing damage. Because, when you're in the military around with the explosions and the firing of the artillery and all the rest of it, there's some noise involved. So there were quite a lot of people who had quite a lot of hearing damage in the military. Well, 3M has agreed to settle this case, agreeing to pay about $5.5 billion in relation to these defects, but this is about half of what people had expected. So 3M is actually getting a good deal out of all this. So let's learn a little bit more about what's going on in this hearing-related lawsuit. Let's get started with this. 3M has tentatively agreed to pay more than $5.5 billion to resolve 300,000 lawsuits, claiming it sold the U.S. military defective combat earplugs. People familiar with the deal said. The settlement would avert a potentially much larger liability that 3M had tried to curb through a controversial bankruptcy case that ultimately collapsed. So one of the things 3M tried to do to avoid liability on this was trying to say this was really not really 3M as such. This was a subsidiary company. This was a subsidiary company, and that company was bankrupt. So therefore, the liability would be limited to that company and not get to 3M proper. So they tried to cabin this off, right? Trying to create liability by creating separate companies for each thing. And that company is bankrupt, so there's no money. And through a various legal, analysis, that didn't work. So they tried to subvert this by claiming all the damage came from a company that wasn't 3M, but the judge didn't buy it. So they're like, okay, you're going to be liable for something. The sum is roughly half of the $10 billion some financial analysts have predicted 3M could pay over the allegations that earplugs did not adequately protect the hearing of the service member. Bloomberg had previously estimated the company's potential liability was $9.5 billion, while Barclays put it around $8 billion. So, we're talking about some pretty serious hearing damage because, once again, the military, with the artillery and the bombs and the explosions and the ordnance and the grenades and the machine gun fire, quite a lot of stuff that might be damaging to the hearing. So yeah, and a lot of people were potentially injured by this, potentially permanently. So yeah, so there was a lot of concern, but apparently 3M got out for about $5.5 billion. So apparently this is a good deal for 3M, given the litigation has been weighing on them for the better part of a decade. That's true. This case has been going on for a hot minute now in terms of this. This all goes back pretty far at this point in sort of this liability. 3M is trying to do everything possible to escape liability, as you might imagine. So it's been going about that well. 3M, for its part, said the company will not comment on the rumor or speculation. So the deal has not been finalized, or at least has not been publicly announced. And so 3M won't comment about it because they don't comment about ongoing litigation, which, fair enough. The accord, if it finally goes through and would be approved by the judge and all the rest of it, would end the torrent of litigation facing the company, even if it faces thousands of other lawsuits over other things. So of course, 3M, this isn't their only lawsuit that faces them. The hearing protection with the double ends that don't quite create a proper seal. Yeah, they're also facing lawsuits over chemicals that are difficult to remove from the water supply, known as forever chemicals, because they're difficult to remove. And so they create toxicity potentially to people. And so they're facing a lot of lawsuits over those chemicals as well. 3M has lost nearly 10 of 16 early trials over the earplugs, with $250 million awarded so far to more than a dozen service members. So it wasn't going well for them, all things being considered. They lost their attempt to shield themselves in bankruptcy. Then, as to some of the trials, they've lost the preliminaries. They've already had to dole out money. So they finally realized, well, now's as good a time as any to strike a deal. So that's what they're doing. In the most recent trial, the Florida jury ordered the manufacturer to pay a U.S. Army veteran $77 million in damages over hearing losses from the earplugs. This particular individual, who had tested weapons over a 4-year period starting in 2005, said he developed hearing loss and tinnitus, which is a constant buzzing noise in the ear, which, would be massively, massively annoying. A noise that never stops. So, yeah. The hundreds of thousands of lawsuits had been consolidated in a multi-district litigation before a federal judge in Florida for pretrial information. So this is pretty typical, by the way, when there's a lot of lawsuits in a lot of different places over essentially the same thing, right? In the name of efficiency, the courts will consolidate them. So there are rules for this, as you would expect. So various people will file various lawsuits in different parts of the country, as you might expect, and all those places might be individually valid. So you have litigation occurring over similar facts, because basically the earplugs were defective is basically the underlying claim at the root of this. So very similar facts from various people in various lawsuits. So, you start getting enough of these things in enough places, in enough districts, and the federal courts are like, wait a second, we can't help noticing that there's a lot of these things, right? And so now we want to consolidate this in the name of efficiency because they all root around this same common fact pattern. There's definitely differences to be had in individual cases, but there's also a lot of commonality. So there's a rule for this in multi-district litigation. So long story short, the federal government will just pick a place. It's a little bit more complicated than that, but they'll pick somewhere, anywhere, that will decide all the issues for all the cases happening everywhere to the extent that there are commonalities. So that, we don't have to relitigate the same thing, 100,000 times. We can relitigate it once and, make our lives easier. So that's something the federal government does in the name of efficiency. It's kind of like a class action, except it's kind of not voluntary, right? So class action is where a bunch of plaintiffs are doing this voluntarily by bringing themselves into a class. This is where the federal government's basically forcing them into a class because it's like, well, there's enough commonality here. We only want to do this thing once. So that's kind of similar in that way. In the lawsuits, current and former members had alleged that 3M knew its earplugs were too short to work effectively and that it failed to warn the U.S. government to take steps to fix the product. So they knew of the defect, which goes a long way to their liability. Under the terms of the proposed settlement, the makers of the earplugs would pay out the money over a term of 5 years. They said the 3M board, of course, must still sign off on the deal as well as the judge themselves, and people who have objections to this can also file objections as well. Turning to the legal question about the liability in terms of the bankruptcy, as I mentioned a little bit above, 3M had sought to limit its liability by having its aereo technology units seek bankruptcy protection from creditors. So the idea was it wasn't 3M that was responsible. It was this company, Aereo Technologies, that was responsible. So they wanted to cabin the liability to this other company, which didn't really have any assets. So it's like, well, we're basically judgment proof, so there's nothing to do. Critics, including law professors and consumer advocates, attacked the maneuver as an example of a company using the process as a shield without filing for bankruptcy themselves. Like, we only want bankruptcy for the subsidiary company, not for 3M itself. So only the subsidiary company is bankrupt, only its assets are gone, so you have no redress, was the idea. The courts didn't really buy that. In June, a bankruptcy judge threw out the case, finding that 3M wasn't in the kind of financial trouble that warranted using the system to manage litigation. They had appealed the ruling. A similar move by Johnson & Johnson over its cases revolving baby powder was rejected under similar grounds. So yeah, 3M isn't the only company that's tried to do this. It's like, let's create a wholly owned subsidiary, and they're the ones that have the liability. And then, oh my God, there's no money there. Oh, that's too bad, so sad. So yeah, definitely some lawyers have tried this maneuver, and at least in 2 different cases, it wasn't successful. So maybe a cautionary tale for lawyers trying to structure out these liability protections in the first place. As the 3M bankruptcy case, was ongoing, lawyers for the company and service members also simultaneously pursued settlement in mediation, required by the judge overseeing the earplug litigation. So while the whole bankruptcy issue was trying to be decided, the judge who was overseeing the case was like, well, I'm not going to wait for the bankruptcy court, at least into this. I want you to undergo mitigation. So yeah, the district judge ordered 3M in May to travel to Florida for the negotiations. So it's like, yeah, I want you to try to settle this thing, regardless of what the bankruptcy court does, or at least like get the process underway so that we save ourselves some time on the back end. According to the lawsuits, the earplugs were defective over a 12-year period starting in 2003. In 2012, there were about 971,000 claims lodged with the Veterans Administration, and claims are expected to rise by 15% in the upcoming year. So quite a lot of claims. This earplug deal is not 3M's first. In 2018, after a whistleblower lawsuit, the company agreed to pay about $9 million in civil allegations by the Justice Department that it failed to disclose defects it knew to the military. So the Justice Department also trying to go after 3M for $10 million, which 3M is like, let me look in my sofa cushions. I think I've got $10 million in between the cushions that I could give you. So not much of a penalty, but they might notice $5 billion, maybe. As for the forever chemical litigation that's already underway, 3M has agreed to pay so far as much as $12.5 billion to clean up the water supply. So they're trying to also settle out liability as it relates to that too. Thus, that brings us to the end of the coverage for the moment about 3M and their earplugs. So their earplugs had a defect. They were designed with two sides in them, right? One side for one kind of protection, one side for a different kind of protection, depending on your needs. Two earplugs for the price of one, but actually 0 earplugs for the price of one because the nature of it prevented them from working properly. And apparently 3M knew that and sold them to the military anyway. So all kinds of stuff. A lot of service members had a lot of hearing problems, and 3M has tentatively agreed to pay $5.5 billion in settlements. This, of course, still has to be approved by the judge themselves, and class members, of course, can object as to whether or not they find the amounts sufficient or not. So we'll see how that all process goes. And at least for the moment, that brings us to the end of discussion of this story.